Welcome to a podcast from the 43rd Annual Conference of the National Center for the Study of Collective Bargaining in Higher Education and the Professions at Hunter College. The conference took place on April 3rd, 4th, and 5th of 2016 at the CUNY Graduate Center in New York City.
Good afternoon, folks, and thank you for coming and participating in this dialogue about mandatory reporting. My name is Jeff Frumkin. I'm the Associate Vice Provost for Academic Human Resources at the University of Michigan. On our panel today, we have Ms. Coleen Chen, who's a senior attorney with the U.S. Department of Education, Office of Civil Rights. Seated next to her is Yael Wepman, who is the Director of EEO and Title IX Coordinator for St. John's University. And here representing the home court is John Rose, who's Dean of Diversity for Hunter College, City University of New York. I have very limited prefatory remarks before we will move to Coleen. I'm assuming that many of you, if not most of you, support the idea that if we become aware of an alleged situation of sexual misconduct with respect to one of our students, that we want to do something about it. Because of the nature of the academy, in fact, some would say its peculiar nature, and that's a non-pejorative, we don't always know what to do, what the something is. And it will probably be different from institution to institution. So it is that something that we are doing that becomes the subject of our conversation today. We're going to begin with Coleen Chen from the Department of Education, Office of Civil Rights. And she will speak for, well, she can speak for up to 15 minutes. I think she's told me she won't. But we will start with her, and then we will have John speak about what's going on here at Hunter, and then Yael at St. John's, and then we'll open it up for your questions and comments. Coleen?
Great, thank you. Hi, again, my name is Coleen Chen. I'm with the U.S. Department of Education, Office for Civil Rights. So I'll start with my time just giving a brief explanation and background about our office, the work we do, and how it particularly pertains to Title IX. And then the second piece of my remarks will discuss the issue of the afternoon, faculty as mandatory reporters under Title IX. So the Office for Civil Rights, as you may already know, is an office within the U.S. Department of Education. And we're responsible for enforcing certain federal anti-discrimination laws that prohibit discrimination on the basis of race, sex, age, and disability. And the primary way that we do this is through investigating complaints. In particular to this panel discussion, we enforce Title IX, which, as you know, is the federal federal sex discrimination law. In particular, we try to ensure that colleges and universities appropriately respond to sexual violence and harassment complaints and make the appropriate efforts to try to prevent sexual violence and harassment from occurring on college campuses. With respect to how our office is organized, we have 12 offices across the country. We all report to our headquarters office in Washington. I work out of the New York office, and we have jurisdiction over New York, New Jersey, the U.S. Virgin Islands, and Puerto Rico. In terms of our investigatory work, we're a neutral fact finder, so we represent neither the complainant nor the school. So when we receive a complaint, we evaluate it in order to determine whether or not we have jurisdiction over it. If we do have jurisdiction over it, then we open the case for investigation. If at the end of our investigation we find a violation of one of the laws that we enforce, we enter into what we call a resolution agreement with the college or the school to address whatever violations that we found. We also monitor the school's compliance with that resolution agreement. One question that we sometimes get is how do we ensure that colleges and schools comply with our investigations and with our resolution agreements? And the answer to that is that if we find the college is not cooperating or the school is not cooperating, with the investigation or with the resolution agreement. If they're not complying, then we have the authority to withdraw their federal funding. Another piece of our work, in addition to responding to complaints from the public, is that we have the authority to initiate our own investigations of particular issues within our jurisdiction, and those are called compliance reviews. Another piece of our work is to provide technical assistance. So that can include speaking at conferences like this. It can include providing trainings to not only to schools and colleges, but also to training presentations to advocacy groups of students or parents. We're also available to answer questions from the public. We have a hotline that's open during business hours, Monday through Friday, where not only can parents and students call with any questions, but also college or school staff can call us with questions they have about the laws that we enforce and whatever particular issue they're facing at their school. With respect to sexual assault issues, as you may have seen in the media, our office is investigating many sexual violence and harassment cases across the country at many colleges and universities. We've also issued guidance in the past few years about this topic. One is the Dear Colleague letter that we issued actually 5 years ago today, April 4th in 2011, the Dear Colleague letter. We also issued in April 29th of 2014 a frequently asked questions document about these issues. Those issues are available in your conference materials and also, of course, on our website. So in terms of the topic of the afternoon, faculty as mandatory reporters under Title IX, the short answer is that OCR does not have any particular requirements whether or not all faculty or some faculty should be mandatory reporters. The longer answer is that what OCR is most concerned about is whoever the college designates to be a mandatory reporter, that complies with OCR's guidance with respect to quote-unquote responsible employees. So responsible employees is a term that you'll see in our Dear Colleague letter and in our frequently asked questions document. So I'll explain more about what OCR means by responsible employees and mandatory reporters in general. So why are responsible employees important? So OCR deems a college to have notice of sexual violence if a responsible employee knew or in the exercise of reasonable care should have known about sexual violence. So basically, the responsible employee puts the university or college on the hook for knowing about a sexual violence complaint and also triggering that college's obligation to respond to a report about sexual violence. So that's why the responsible employee concept is important in our guidance. There are three elements to the definition of responsible employee in our guidance. Two of the elements are very clear. The third is not as clear, so I'll go through each of them. The first element of the definition of a responsible employee is someone who has the authority to take action to redress sexual violence. So the clearest example of that would be the Title IX coordinator. So somebody who is in charge of coordinating the college's response to a sexual violence complaint and ensuring that the response is appropriate. The second element to the definition of a responsible employee is someone who has been given the duty of reporting incidents of sexual violence to the Title IX coordinator or the person in charge of responding to those complaints. So that's where, this is the definition of who is designated to be a mandatory reporter by a college. So somebody who is designated to be a mandatory reporter has to report the sexual violence claim up to the Title IX coordinator or whoever is in charge of responding to a sexual violence complaint. The third element is the third and final element is the element that's a little bit less clear. A responsible employee includes any employee whom a student could reasonably believe has this authority or duty. So, it's clear that this is a little bit less clear. So basically in this third element of the definition, it's somebody the student could reasonably believe has this authority. Not necessarily somebody who has been affirmatively designated this authority, but somebody who the student could reasonably believe who has this authority. So OCR has some guidance that fleshes what this means. One of the examples it provides is that the way to interpret this can also be influenced by the age of the student. So one example that the frequently asked questions document provides is that it might be reasonable for an elementary student to believe that the person who oversees the cafeteria and is in charge of supervising meal times would have this type of authority. But on the other hand, somebody in college, obviously it would not be reasonable for a college student to believe that somebody overseeing cafeteria issues and meal times at a college would have this authority. So that's one example that OCR provides to try to flesh out that example a little bit. So in terms of responsible employees, there's two types of buckets of responsibility that a responsible employee has. One is about what the responsible employee is supposed to report up to the Title IX coordinator, and the other bucket of responsibility is the information that the responsible employee is supposed to report and provide to the complainant. So we'll break that down a little bit. So with respect to what a responsible employee is supposed to report up to the Title IX coordinator, again, this triggers the school's response with respect to a sexual violence complaint. The responsible employee is supposed to provide to the Title IX coordinator or whoever is in charge of responding to the complaints the names of the victim, the alleged perpetrator, any students who might have witnessed the alleged incident, and any other relevant facts, such as, of course, the date, time, location of the incident. In terms of what a responsible employee is supposed to inform a complainant, the responsible employee is supposed to inform the complainant of the responsible employee's obligation to report the incident up to the Title IX coordinator. That's one thing the responsible employee is supposed to let the complainant know. The second item is that the responsible employee is supposed to let the student know of his or her right to request confidentiality, and that the school will review that request for confidentiality, and that the student can also speak with confidential advocacy resources such as counseling and support services. The third element that a responsible employee should inform a complainant is that the complainant has the right to file a Title IX complaint, not just with the college, but also with local law enforcement agencies. And so I think since there's no, again, OCR does not directly mandate whether or not some or all faculty should be mandatory reporters, but I think one of the important messages OCR has is that whoever is designated to be a mandatory reporter, that person needs to be obviously trained about the responsibilities, and the training should not only be targeted towards obviously the responsible employee or the mandatory reporter, but also to the students. So the students and the rest of the college community need to be educated about who are the responsible employees and who are the mandatory reporters who are able to address these situations. And I think that's all for my comments.
Okay. John?
Thank you, Jeffrey. Good afternoon, everyone. My name is John Rose, and I am the Title IX coordinator at Hunter College, and I'm glad to have this opportunity to share a discussion about responsible employees and how Hunter College, a part of the City University of New York, interprets that phrase in its sexual misconduct policy. I think we've heard here that while we all may agree upon an ultimate goal with respect to making sure that sexual misconduct is rooted out of our campuses and reported and investigated promptly, that there are, even with that goal in mind, there are many different ways to achieve that end, and each institution has to determine what's most appropriate for it based on a number of factors. So I want to walk you through some of the goals that we have at Hunter College and the City University, and how we have applied the guidance that we've received from OCR, and how we've interpreted the FAQs, and how we have come to the conclusion that faculty on our campus who are serving simply as faculty and not in other capacities are not responsible employees under our policy. So our goals generally with respect to sexual misconduct are probably no different from many other institutions, like my colleague here, Yael at St. John's. We are committed to promoting a safe and secure academic environment. After all, we are in the business of generating knowledge and learning and research, and that really needs a certain environment to take place in, and where people feel that they are at risk is inherently inconsistent with the environment that we want to preserve. We want to prevent any kind of sexual harassment, sexual assault, or sexual violence on our campus. We want our policies to be clear and forceful in terms of articulating our expectations, our behavioral expectations as the students, and our reporting expectations as the members of the community. We want to make sure that we provide appropriate education and awareness so that people are knowledgeable about those policies. And of course, we want to be able to respond appropriately when instances are reported, and to take actions that are that resolve the issue reported and that prevent any subsequent misconduct. So we obviously, to advance these goals, want to make sure that all members of our campus community are aware of our policies and expectations when it comes to matters of sexual misconduct. Now, in determining who is a responsible employee in terms of who has a specific duty either to report to me as the Title IX coordinator, any matters that come to their attention, we have been informed and by the guidance of OCR and by the FAQs that Coleen referred to a moment ago. That guidance not only leaves room for interpretation, but in my view actually invites interpretation, because it says that I might add the FAQs that I have in front of me. Actually, I never leave home without it because it's so important all the time. It asks, who is a responsible employee? That's the question. And though the answer could have said a responsible employee is people who have the title of, it doesn't. It does articulate the three elements that Coleen talked about, but then it also says, and I quote, whether an employee is a responsible employee will vary depending on factors such as the age and education level of the student, which Coleen had referred to before, the type of position held by the employee, and consideration of both formal and informal school practices and procedures. So when we look to formal and informal school practices and procedures, and we look to other issues such as our culture, our customs, and our practice, I think we have collectively come to the conclusion that in our campus culture and environment, we would not believe it would be reasonable for a student to assume that a faculty member serving as a faculty member, faculty qua faculty, can be viewed as a person who can solve any issue that a student might have regarding their life outside the classroom, whether that issue occurred on or off our campus. For one thing, our size and our scale and our scope, we have 24,000 students at Hunter. I think somebody earlier said that at the lunch, they said that City University has something like 500,000, and when you count both full-time and part-time students, 500,000 students, 1/16 of everybody in the city of New York. That's pretty remarkable in terms of size. We're a small part of that, but an important part of that, with 24,000 students, graduate, undergraduate, second-degree students, most of whom are commuters, attend classes from 7 in the morning till 11 at night. Typically, we have 3,400 employees, including about 1,800 faculty. when you have that size and scope and dimension, it prevents the kind of closeness and intimacy that exists on many other campuses when faculty members are individuals who students see throughout the course of the day and have some ongoing familiarity with. And although we acknowledge that when it comes to questions, concerns, or opinions about the subject matter of a course a student may be taking, then in that circumstance, the faculty member teaching that course is seen to have the authority and the ability to resolve issues and problems. And our view that authority and ability does not extend to subject matter expertise beyond the course that's being taught. Now, in terms of campus processes, we have systems in place that direct students to specific faculty members, to professional staff, or to governance groups with the capacity and the ability to resolve students' issues. So, for example, in terms of academic matters, such as the requirements of a major, course sequences, how a major might help a student's career goals, or questions relating to course prerequisites, students do not necessarily believe that the teacher they have in any particular class has the answer to those questions or is the authority on those questions. On our campus, when a student needs advice or guidance on academic issues, they usually go to the faculty advisor specifically designated by the academic department to serve as the faculty advisor, or they go to a student affairs academic advisor. The academic department's designated faculty advisor may, in fact, be the person who's teaching a particular course, but that is just a happenstance. And the students understand that just because someone is teaching the course doesn't mean that they are the authority or the person who can help clarify or resolve non-course matters. But even as to classroom academic matters, the classroom teacher does not have broad authority to handle matters of student misconduct. For example, if a student misbehaves in a class in a manner that is disruptive to other students, the classroom teacher does not have authority to expel that student from the classroom. The misbehavior may, at the discretion of the classroom teacher, be reported to an administrative team that will determine the most appropriate resolution. Similarly, as to classroom matters of academic integrity, such as plagiarism or cheating, the teacher who suspects or uncovers such conduct does not have the power or authority to address it. The teacher has the discretion to refer the matter to an academic integrity office, which then investigates and resolves the issue. So the mere title of faculty, professor, associate, assistant professor, instructor, does not, on our campus and in our culture, automatically confer broad authority to address academic issues. Now, this is even more so when it comes to non-academic issues or matters which occur outside the classroom. When a student has a personal matter, such as finances or housing, the faculty member is not seen as the individual with the ability to solve that issue. It is possible that if a student cannot complete an assignment because he or she has suddenly become ill or homeless or is facing some other emergency, the student may mention this to the faculty to seek relief from a paper, a test, or a homework assignment. But the student does not expect that the faculty will solve their underlying problem. What happens typically is a referral to someone else that's been designated to handle that issue. So when a student has a personal issue of a psychological or emotional nature and needs to speak to someone, they usually contact our counseling and wellness center, whose staff under our sexual misconduct policies are considered confidential employees. Now, in those circumstances when there is a special or ongoing relationship between the faculty member and the student, such as when the faculty is leading students on trips away from campus or serving as an advisor to student clubs or organizations, then in that role, the faculty is deemed a responsible employee with a duty to report any sexual misconduct that comes to their attention. We have a very broad definition of who is a responsible employee, which includes those in both the category of people who have the ability to specifically redress sexual misconduct, myself, Vice President of Student Affairs, the college president, and then people who have specific duties who have the responsibility to report up issues of student misconduct which occurs or which comes to their attention, and that includes a whole host of people from residence life staff, athletic staff, faculty who serve as department chair people who, by the way, under our system also have managerial authority within the departments, HR staff, college attorneys, as well as I mentioned earlier, faculty who are leading, who have special relationships such as leading student off-campus trips, who serve as advisors to student groups generally. So while faculty, qua faculty are not responsible employees under our policy, we do encourage all employees to report issues that come to their attention and to speak up if they know that they're about misconduct that is harmful to a student, even if they may not be under a particular legal obligation to do so. One last thought. For purposes of this panel, I look to see if there might be some generalized duty of care applicable to faculty or to institutions of higher education under the in loco parentis doctrine, which has been floating out there and gotten some legal attention recently. But the case law I've been able to find that involves post-secondary institutions suggests a narrowing of the applicability of this doctrine. And although faculty and staff in higher education clearly impact students' lives, the narrowing case law seems to suggest that students at higher education institutions are young adults who believe to have a higher level of responsibility for their actions and decisions. And we think this development is consistent with our policy of seeing students as people who don't necessarily rely on teachers to resolve all of their challenges and difficulties, and may not necessarily be inclined to bring all of those challenges and difficulties to their teacher. My last point is that the CUNY sexual misconduct policy is an evolving document. We've changed it in light of any number of legal changes recently. Last year with the New York State Enough is Enough law, it changed again. So it is an evolving document, a living document, and it will continue to reflect not only legal or regulatory requirements, but experiences that we may have on our various campuses. So the fact that it's a living document gives us a chance to re-examine who is a responsible employee and to make changes if we find that it's warranted in the future.
Okay.
Thank you.
Thank you very much, John. Thank you for adding that piece about in loco parentis. Yael,
Great.
what's happening at St. John's?
Hi, I'm Yael Wepman. I am the Director of EEO and Compliance and also the Title IX Coordinator at St. John's University. I'm pleased to be sharing this discussion with you all today. So St. John's, unlike Hunter, does take the position that all faculty are required to report all instances of sexual misconduct that they learn about, whether it's through a direct report or because they witness something, they see it on campus. And we came to this decision considering many of the factors that John had talked about in terms of keeping our campus community safe, ensuring that we adhered to our mission, which really is to foster a caring and nimble environment, one where we believe is free from harassment and discrimination, and also to point out that we have always not mandated in the sense that we had it written in a policy that all faculty are mandated reporters, but required our employees in certain levels to report any instances where students disclose harm to self or harm to others. So with that backdrop, when we started considering the what to do with who should be a responsible employee as per the DCL, we were considering these things. And I don't want to go into all of or read you all of the same pieces of guidance that both Coleen and John read to you, but I'll just state that we did consider in the frequently asked questions the definition of a responsible employee. We also considered the definition under the 2001 DCL, which was reiterated later, of who has what a responsible employee is, and particularly focused in on the nuanced language of the third prong, which is a responsible employee who is an individual who students could reasonably believe has the authority or responsibility. In addition to focusing on those definitions, we were looking at the 2014 Q&A, specifically J1, where OCR wrote in response to the question about the type of training that a school should provide. And I apologize for reading, but it was just too much for me to really remember. But the response states that, and I'm paraphrasing a little bit too, but a school needs to ensure that responsible employees with the authority to address sexual violence know how to respond appropriately to reports of sexual violence, and that other responsible employees, that's my emphasis, know that they are obligated to report sexual violence to appropriate school officials. A school should provide training to all employees who are likely to receive a report of sexual violence, including teachers, and this training should include the responsible employees' reporting obligations. So that, coupled with the 2001 DCL guidance and also the 2014 Q&A A4, when does OCR consider a school to have notice of student-to-student sexual violence? And that notice can be received in many different ways. Examples include a report to a teacher, or if a teacher witnesses an incident, made St. John's take a look at what are we doing, how can we take prompt and effective action in response to sexual harassment, remedy any effects, and prevent the recurrence if that responsibility is triggered with notice, and that notice being to a teacher based on the myriad of different guidance that I just read to you. And so we have come to the conclusion that our teachers, or our faculty in particular, are in that position of likely to receive reports, and that they are responsible, and that from the standpoint of doing the right thing for our culture, as I started with our mission statement, we want to ensure that our complainants are provided with the greatest opportunity for resources, support, accommodations, and that our Title IX team at St. John's is the most appropriate venue for all of those resources, accommodations, support, the right to notify local law enforcement. We can put that all in place in the maximum way possible that will be most beneficial to a student victim. Specifically, I use the example in our training when, if there is any pushback, which sometimes there is, if the question arises, I feel that there's a trust, there's a relationship here, I don't want to violate somebody's privacy, they've come to me for a particular reason, and from the standpoint of St. John's, well, that might be true, and you as a faculty member might be able to help that student right now in the present in your course or getting through homework or something that's going on in that moment. But in terms of long-term support, long-term resources, long-term accommodations, our university has put into place a myriad of different mechanisms to best provide those things for our students. So if a faculty decides on his own or her own volition to, say, allow a student to continue the remainder of the semester in that particular class in an online format for whatever reason, what happens in the following semester if the student is placed in a classroom with that alleged respondent? And we have the ability to change classrooms, we have the ability to change housing, we have the ability to get a student to our counseling center if they want it, or to help them with filing a complaint with local law enforcement. And in fact, we have a great relationship with our local precinct where they will come to us as long as they're not extremely busy. But it makes the process much less daunting for a complainant who does choose to file with local law enforcement. And so we really feel that having a centralized approach or a centralized reporting process, utilizing faculty as those responsible employees, helps to ensure the greatest benefit or the greatest impact in a positive way for our complainant victims. And to ensure that also we can take prompt and effective action to end the harassment. In terms of other potential obstacles or some other issues that have been brought up in our training, John mentioned when a question arises about the free conversation in a classroom or the composition that a student writes disclosing an incident of sexual misconduct, that is not included within our obligation to report, so that if a faculty is teaching a course and the student discloses in the context of that course, we are not requiring the faculty to come forward because that is impinging on that free conversation in the classroom. The other pushbacks that we've seen, or some other obstacles that we've seen, really have to do with getting faculty to come to our training so that they can become aware and intimately familiar with our reporting and responding to sexual assault on campus protocol. And while I say it's been a little bit of an obstacle, I've come out ahead of that, and we've put in some training sessions that were specifically targeted for faculty, where I worked with the deans of the colleges to schedule sessions that are around faculty's schedules, and made it open only to faculty of specific departments. I've gone to dean's council meetings, chairs, faculty council luncheons, all different ways to ensure that my faculty, who I've now designated as responsible employees on our campus and charged the responsibility to report all instances of sexual misconduct which they could become aware. And so as part of that, I felt that it's important that they know what policy they are required, what they are complying with. And so I've tried to avoid any ability for them to kind of skirt this responsibility by going out and really having them sit in a classroom setting. And we do our trainings in person, and they last about 2 hours. So we have been taking it very seriously, and I think that goes to the fact that St. John's really is not just responding to a legal mandate, but we're responding on the basis that this is what we feel is the right thing to do. And long before the Office of Civil Rights came in and said, you know, certain employees must be responsible employees and are mandated under the law to report instances of sexual misconduct, we've been saying we want everybody to report this regardless, because we want to make sure that we ensure the safety and security of our campus community. So I think that's all I have, actually.
Okay. Thank you, all three of you. I'm going to open the floor up for questions or comments in just a minute, but I actually have a question for Coleen, I have a question for Yael and John, and I have a question for the audience. For Coleen, as you were talking about the fact that one of the sanctions could be loss of federal funding, which I know comes up in every meeting I have on campus, but my first reaction was, ask Coleen, have they ever done that? And no, I'm not going to do that.
I don't think we have.
But have the, what are the kinds of, in general, the kinds of compliance pieces that the OCR and the institutions have put together, just sort of the framework of those? For Yael and John, when you're doing training, what are the kind of questions or pushback questions are you getting? And then for the audience, since this is also a collective bargaining conference and none of us, I don't have to bargain this, although I'm a bargainer, and none of the three of the folks here are bargainers, if anybody has any experience with this. So if we could take just a minute or two for each of you to talk about the questions I have, and then we'll get right to you folks.
So with respect to the framework that we use to work with colleges with respect to
What
compliance?
might be a typical kind of sanction short of, we're going to take your federal funding
sanctions.
away?
Oh, okay. I mean, for the most part in our experience, at least my personal experience working with these types of cases and investigating them, is that colleges have been very cooperative and have been working very hard and very intensely in order to comply with our requirements. I mean, as you know, it's not just OCR that is out there. There's also the Clery Act, there's also the White House Sexual Assault Task Force. I mean, there's multiple pieces of guidance that colleges and Title IX coordinators need to comply with, and I think, and also, of course, state law as well. So I think our experience has been that colleges have been working very hard to comply with our requirements. I mean, obviously, there are questions, there are gray areas that we try to resolve as clearly as possible, but in terms of sanctions, I don't think there hasn't really been that type of situation, thankfully.
Okay, thank you.
Sure.
Yael, why don't you go first this time?
Sure. A couple of things that in terms of training issues that have come up, I had mentioned as being some obstacles. In addition to the things that I mentioned, I've had some questions about either faculty not believing complainants when they come forward, particularly when complaints are made against other faculty. And I think that's my most frequently asked question is, how often are complainants lying? How do you know if they're lying? What should you do if they are lying? I know that they are lying. I've been accused before. And the question comes in many different wrappings. And the reality is that we believe a complainant when he or she comes forward with a complaint, and we let our process play itself out in a fair and impartial manner and try to explain why we are in the situation that we're in today, where we are lecturing or facilitating a 2-hour dialogue on Title IX and reporting and responding to sexual assault on campus, and pointing back out to statistics of incidents of lying or incidents of the staggering number of students who are assaulted on campus. And so I try and go back at these accusations with fact, and particularly when it pertains to complaints against faculty and their position, which has been the case that I've seen, the position that students are lying because they want a better grade or they want to change a faculty, the class that they're in, explain that there are other ways that that could happen without coming forward with a complaint of sexual harassment or sexual assault.
Thank you. I recall similar conversations on our campus, too, about all we want the responsible employees to do is report, not try to solve or adjudicate it. Right. John, how about for Hunter?
Well, I was smiling when Yael was talking about the challenges of working with the deans and going around and trying to find a moment when faculty was available, because I've been there and done that and had many of those same kind of problems. So when we do responsible employee presentations, some of the questions we've gotten really relates to, oh my God, I really have to do what? I have to tell the student what? And so it's not just, if you hear about things, if a student comes to you, you not only have an obligation to report it up, but theoretically you've got an obligation to disclose certain information to students as well. And so making people sort of aware of that and making them comfortable in discharging that obligation. And I know some institutions, Yael and I, by the way, are in a working group that meets Title IX administrators in the metropolitan area. So sometimes we share practices that the other or copy practices or steal practices from the other institutions. And I know that some institutions like to give faculty cards that they can hand out to students, and we typically provide, at the end of my responsible employee presentations, copies of our students' Bill of Rights, which describes many of the options they have in terms of confidentiality and going to police, et cetera, and access of resources. We also provide faculties with our resource list, because those are the two most frequently asked questions at the end of the responsible employee presentation. The other question that I get has to do with what is notice. And so, notice can slap you in the face because somebody comes to you and says, something happened to me. Notice can happen as you're walking down a hallway and you overhear a conversation that puts you on notice that there's something that is taking place. Notice can occur when you get something out of the blue over the transom or however it comes that suggests that something occurred in a residence hall or at an event off campus. Each of these things must be reported, I tell them. So it's not just if it is a very clear case of somebody coming to you with a complaint. If you learn about a circumstance that suggests that sexual misconduct has taken place, it's your duty to tell me what you've learned and to tell me as soon as you possibly can. And making people understand that really has become, I've noticed that consistently been questions that arise, has become an additional FAQ, if you will.
Right. Okay. Thank you, the three of you, for being so patient. If you would tell us your name and the institution you're from, and go ahead and with your question or comment.
I'm Mary Ann Mahoney from Central Connecticut State University, where I'm the AAUP chapter president. Okay. And I have a couple of questions. One is that on our campus, the Office of Diversity and Equity has interpreted the definition of responsible reporter and what needs to be reported in the most broad possible terms. So all faculty are responsible for reporting any incidents of sexual assault or sexual harassment that may have occurred at any time to the student or anybody else on campus, even if it was 50 years ago. And this has caused for many of our counseling faculty, not who are actually responsible for counseling, but who teach social work, marriage and family counseling, psychology, and who are also licensed practitioners, this has raised some real concerns for them. And it's also raised concerns among our Committee on the Concerns of Women, that that the requirement not just to report a sexual assault that might have happened yesterday or today, but something that happened in the student's childhood, really is interfering with the ability to teach classes. And I wonder if you could just comment on that sort of broad definition of what it is we're supposed to do and who is supposed to do it. Thank you.
I mean, I could speak to what we do in my school, but I also think that Colleen's response could be grounded in a FAQ response that specifically speaks to an exclusion from my interpretation of what you're describing. And I feel like a little bit that I'm responding in a vacuum without actually looking at a syllabus and looking at what the course material is and looking at the type of disclosure that's being received. But based on what you're explaining in the FAQ, it seems that there would be an exclusion from requiring faculty to report that in the context of the course.
Right, my understanding is that if the faculty are serving as that student's actual confidential resource or providing direct support to the student, then that's definitely something that's excluded from the mandatory reporting requirements. I'm not specifically sure if there's a carve-out for reports that are made in the context of an actual course. I think that's up to the colleges to decide on their own. Like, as Yael was saying, with respect to St. John's, incidents that come up during the course of a for example, during a paper or during the class discussion at St. John's, those are carved out from the mandatory reporting requirements. I think it's up to the colleges to decide, but it needs to be something that's very clear. I don't know if you want to speak more about the carve out.
I thought that there was an actual
FAQ?
yeah, an FAQ on this that I've read.
I don't remember offhand, but
Okay.
don't quote me on that.
I'm pretty sure I've read
Okay.
that there is one for specifically and mine might be a little more broad than what it reads, but I think it reads compositions in the context of a class.
Okay, thank you.
I don't know if they're addressing the ongoing trauma of a pre-existing sexual assault, but obviously something that took place many years ago before they were a student isn't something that the Title IX investigator could reasonably investigate and make a judgment on, although the Title IX person is supposed to identify resources that may be able to support the student, and they may be asking for that to be served up so that they could identify whether there's a resource that can be of assistance to the student. But it's hard for me to see an investigative duty for something that is
Right.
so
It's not clear
disconnected
that
to the
it-
student's experience on campus.
The ODE is saying they won't necessarily investigate, but they're putting the onus on faculty to report anything that they may, say a student writes a short story about an incident of mistreatment well in the past, or to someone else. Anything
Right.
that we become aware of, we're being mandated to report. And in fact, the officer at ODE is being quite, she's actually pretty much come right out and said to new faculty in orientation that if they don't report, that the state of Connecticut won't represent them if there's any action that comes out of it. Now, we don't believe that that's possible, right? But a beginning assistant professor or part-time faculty member doesn't know that.
The other thing that I just want to point out is there could be Connecticut state law that's requiring the reporting of that.
Yeah, I'm not sure. Well, given that Yukon and Connecticut state seem to interpret things differently and both say they're following the law, something tells me there might be some openness to interpretation. But anyway, I'll let other people ask.
you.
Thank you.
So I'm would like to go with the two individuals standing over here because they have been up, and then we'll move to the two of you over there. Thank you. Please, your name and institution.
Yeah, I'm Liz Coles. I'm from Eastern Connecticut State, so the same part of a place that Mary Ann came from. However, I've got a bone to pick, I think, with the board. None of you are faculty members currently. So you've not gone through or suffered through some of the Cleary training and those videos that we had to watch on Title IX. I think the biggest problem I had with those, yes, you have trouble with faculty sitting there and watching those, but to be honest, they're not real life. And secondly, there was nothing germane to my particular institution. So I left that training thinking to myself, okay, I understand that I have to report, but to whom? And I was told by my higher-ups at Eastern, oh, just check the website. Well, geez, I mean, there's nothing worse than trying to find stuff on a website when you've got a student in distress, and trying to figure that out. The second point I want to make is that it cuts both ways, and unless the administration is willing to give faculty support who I have been harassed and had received no support whatsoever. I really think the administration needs to do a far better job in making sure that we as faculty know who do we report to, in what time frame are we talking about, under what parameters do we have to do so, under whose auspices, because quite frankly, it's a test I'm not sure I could pass. Thank you.
Thank you, and I will pass your comment on to the board.
Okay, hello, I'm Sonia Alvarado. I'm the AFT Michigan Higher Ed rep. I want to ask you about your thoughts on graduate teaching assistants as mandatory reporters. We're in the middle of conversations that came out of bargaining with Michigan State. We've put it off for a year as we contemplate what this really means, because there's a kind of conflict between being a student and an employee in certain situations. And that's for anyone that wants to answer that.
Well, I can tell you that at the Michigan State sister institution down the highway 70 miles, while we will be releasing our policy soon, I am told, graduate student instructors will not be considered responsible employees. For the purposes of that act, I want to be careful on the quote on that.
And we're, like John said, we're also in the, well, actually, like John said, the policy and procedures reporting and responding to sexual misconduct on campus is constantly evolving right now, meaning, there's been an onset of different changes that have required us to keep our policy, keep revising our policy, and we're actually in the process of revising it right now. And right now, we have not designated these graduate assistants, TAs, as our responsible employees, but I will say that we are training some of our graduate groups to report instances. So while we're not giving them that title, we still feel strongly that we want to know what is going on our campus. And, I mentioned that my training is 2 hours long. It's 2 hours long because we go through scenarios. How do you respond to a student when they come into your office? What can you say? What do you say before they make a disclosure? What can you say to help them in the instance when they do make a disclosure and they didn't want to and now they're asking for confidentiality? How can you explain to them that you're not the best person to help them through this situation, but that you will stand by them the same way you would have stood by them if that faculty was the only person to have received the report. And so we do some of that same training for our graduate population as well, and we just started because we want to ensure that we have a uniform response on our campus, even though we haven't designated those individuals as being responsible employees.
Okay. Where am I going next? There, here, right.
Hi, I'm Linda Cunningham from Connecticut State University again with that group.
Is
And
anybody here from Connecticut?
Connecticut State University, but I'm with AUP, and we have had some concerns on our campus brought to us by faculty, and in particular part-time faculty. Our faculty have been told that they're designated reporters. Two things that I heard you say is that they need to report any sexual assault or sexual abuse, and that notice includes overhearing a conversation that suggests something occurred. So we've had our members come to us, particularly part-time faculty, that have said, so I will be disciplined if I do not report overhearing something in the hallway, which I may misconstrue. I have to report the names. I have to report all of the information you had said. It could be a 90-year-old or 80-year-old person who is saying that they were abused when they were a child, because that is still called sexual abuse. There's nothing that says on the campus at the time. And then if that comes up later, that it was a mistake, that she or he heard the information incorrectly, because they are part-time, they're in fear of losing their job. That's the scenarios that are coming into our office. It hasn't happened, and I would hope it never would, but that's what our faculty are worried about, and that's why they're worried that they're considered mandated reporters, and they have to report anything they overheard as notice, and that they have to report no matter the age and the event.
Can I ask you a question? How does your reporting structure work that someone who reports an incident of sexual misconduct would be in a situation where the person that he or she reports to, as a part-time faculty member, is in a position to even know that they made that report?
Well, they have to report to the Title IX officer.
But how would the Title IX officer why would the Title IX officer even be connecting with that part-time faculty's department chair or dean that would be responsible for hiring? Because to me, it seems almost like an operator error in terms of the training and talking about how reports are coming into the Title IX coordinator's office and how they're really siloed from the rest of the campus community.
They're not siloed because our Title IX has been the student vice president for student affairs, who work closely with the academic vice president, also with human resources. So they are all interconnected. So they do know.
Well, they may know. I think what Yael is sort of suggesting is that there is, most Title IX investigators proceed on with a sense of confidentiality, so there's a need to know aspect of who learns about a issue that has been raised.
Well, once they start the investigation, yeah.
I'm sorry. So if somebody really is sort of outside the loop of those who need to know, there wouldn't be a natural propensity to disclose the fact that a report had been made by somebody in a reporting structure, because it's not really germane to the investigation.
And especially
What I'm trying to say is if the investigation starts, okay?
Yeah, but
and then the student, but the student didn't want an investigation.
Well, you
and then
just
complains
did
to the
two
university
different
that
situations,
took
because
place.
a student who is coming forward is different than a part-time adjunct or faculty member who's coming forward. And in a situation where they're like, the complaint is, say, 60 years old, in my office, it would be a conversation with that individual. Hi, Professor Jones, I learned that this conversation may or may not have happened. And that's it. I wouldn't be having a conversation with anyone other than the person.
You wouldn't have a conversation with the student that they thought that made the report, that didn't make a report, but did make a report because they made they did do notice, right? So the student noticed. The faculty member overhears a conversation. This student then, it's notice, right? So once the student is questioned, the student complains because of the fact, this is just a scenario that they're worried about. The student complains that they're being questioned over something that happened to them years ago. So then the faculty member who made the report,
I thought you were saying it was the faculty who was the one who was abused a long time ago.
No,
so
I was
didn't
not.
follow.
but
I mean, I would
that could
still-
happen as well.
I would still stand by the fact that it would be on a very limited need to know, and I'm not sure how even questioning the student would put the faculty for reporting in jeopardy in his
Because
or
the
her
student would
job.
complain about the fact that the faculty member has reported something they didn't want known that happened to them years ago.
But again, that would.
Right, so I'm suggesting the student wouldn't necessarily know. I mean, the whole point of it is, you want to get it in the hands of the person who's got responsibility to determine what the appropriate next step is.
Okay, well, I'm just saying our part-time faculty are worried about losing their jobs.
All right.
I understand that, and if I'm understanding where your institution has ended up with is that everybody's a mandatory, all faculty are mandatory reporters, and I would hope that if a student went into a dean and complained that adjunct faculty member X reported me when I said not to, that the dean would say that's because that's part of their job. Now, you live in a real world, I live in a real world, I understand that, but that's supposed to be what happens.
Right, but that's why our faculty are kind of leery about the overhearing and about reporting things from people who had things happen to them way back in their history. They're feeling that's not quite, I mean, statute of limitations has even gone by. So to have to report those things seems like it needs to be tightened up a little.
I want to give you an example. We got a report, it wasn't through a faculty member, but while we are basically a commuter campus, we do have a residence hall as well. And the residence hall has a silent witness website so that people can report issues. We got a report from the mother of a student who lives overseas who overheard her daughter having a conversation with one of our students. So it's a student on our residence campus talking overseas to another student whose mother overheard their conversation. And in their conversation, she detected something that may have happened to our student. And she went on the website and reported through a silent witness that something had happened. And we determined more appropriately that we had a duty to act on that and to commence a question, a gentle question probing if there was something that happened. And we learned about something that the student on her own initiative would not have brought to our attention. So, and the student does not know to this day that is her friend's
Right.
mother who overheard the conversation.
I don't think that's my point. I think part of my point is that if we have senior citizens who say something that happened in their childhood, that has to be reported. That is beyond,
I see what
it's
you're
not
saying.
on campus, it's beyond even the state
see what you're saying.
statutes, limitations, and yet they really don't want it brought up again. They've already kind of, been beyond that in their lives, and they may have just mentioned it in the hallway, and that has to be reported. I find that a little
I think that-
problematic.
Yeah, I mean,
That's all.
Sir?
So I want that tightened up a little bit is all I'm
Gotcha.
Okay.
requesting.
we'll get right to that.
Cliff Johnston from Westchester University, Pennsylvania. I have a quick comment and then two observations that I'd ask Coleen, I think, to probably respond to. The first is, you had asked about people that may have been dealing with this from the labor side of it.
Yes.
And to my colleague from UConn who already made the point, I just want to reiterate, it seems like while colleges were supposed to be making these decisions, it was actually administrators and lawyers, and the faculty were hardly ever involved in any kind of discussion leading to the decision of who was and who was not mandatory reporters. And I find that disturbing, I mean, in a shared governance model. The observations are, Yael in her presentation, and interesting first name, by the way, in her presentation mentioned a couple times from the FAQ language that cited the teachers as part of the lead up to how they came to their conclusion. And I'm inferring from what John in his presentation that Hunter didn't consider faculty as teachers, but St. John's basically did. And again, this is something that I think is a distinction that ought to be talked about more. And what does language about mandatory reporting that mentions school teachers and teachers, is that in fact include faculty? And is in fact, Coleen, any guidance on that particular issue? And then the second observation, which gets into that third definition of what becomes a responsible employee. If enough colleges start saying that all faculty are mandated reporters, responsible employees, doesn't that then lead us eventually to the point where we all have to be? Because any student who transfers in from one college where all faculty were responsible employees suddenly goes to another college where they're not, but don't they have a reasonable expectation that they are, because that's what they came from? And by the time this, give this another 5-10 years, every student's going to be expecting that every faculty member is, in fact, a responsible employee, regardless of what the college has determined. So if you could respond to those 2 points. Thank you.
Sure. So with respect to the idea of if all colleges are requiring all faculty to be mandatory reporters, I mean, I think it's up to the college. Obviously, it's the college's discretion to decide whether or not they want to make all faculty mandatory reporters or not. I think if they don't make all faculty mandatory reporters, it needs to be very clear to the students who and who are not mandatory reporters. The level of the students' knowledge is in part influenced by the college. What is the college telling them? Are they being clear? Is it not clear? If they're, from day one, it's very clear from freshman orientation that they've identified, certain pools of faculty to be responsible employees, then it might be difficult for a student to say, well, I thought this person was a mandatory reporter, and then the college could say, well, we're not sure why you would think that, because it's in every piece of literature, basically, that we've been providing you since freshman year. So I think, that's it's a case-by-case basis. And I'm sorry, with respect to your first question, if you could reiterate that, sorry.
The reliance, it seems in many cases, the reliance on that decision as to whether faculty are mandatory reporters comes down to language that in the FAQs and so forth refers to teachers, and often school teachers. And it seems like that's the easy way. Well, we're faculty, we're teachers, which is true, we are teachers, but that language often doesn't, it's not clear to me that in fact means anything beyond K through 12. Right. And I would like to know if you in particular have any guidance or what you think the intent of that was.
I mean, I don't think there's any more particular clarification about that distinction. I think it's up to the colleges looking at, I know there's many pieces of guidance, not just from our office, but other offices, but what would be, again, the best fit for their particular community, whether it makes sense for all teachers or all faculty to be mandatory reporters or not. I don't think there's any more specific guidance about that distinction between faculty and teachers in that respect.
Sir?
Yeah, hi.
Yael or John, do you have anything you want to add to that? No. Okay. Please, go ahead, sir.
Aaron, this is an AAUP. I had a sort of general comment and a specific question. I think one of the issues that comes up with all of the repeated guidance letters, FAQs, Q&As, they can be helpful, but I think sometimes there's not a clarity in language which causes conflict and confusion. And I'll give you one specific one, which is on this third prong of the mandatory reporter. And I've heard arguments between lawyers who supposedly specialize in this stuff. One group says that a mandatory reporter is anybody who would reasonably be expected to report any student misconduct, which would include plagiarism. Okay. On the other hand, some people view it as any student misconduct related to sexual harassment that you would report to the Title IX coordinator. So it's limited to Title IX issues. So I'm curious from Department of Education's perspective, which one is it?
It's both.
That's a good question. I think our guidance doesn't specifically specify between the two. I know that one of the frequently asked questions talks about residential assistants and whether or not they're mandatory reporters. And I think one of the guidance, or it speaks about how if the residential assistant is responsible for reporting other disciplinary incidents, then that person could be considered a responsible employee. That's with respect to our guidance. I know under the Clery Act, I think residential assistants are technically mandatory reporters under the Clery Act, I think. I think that's one of the understandable areas of confusion with respect to responsible employees and this
so
idea
can
of not
you
just
clarify
graduate
it?
assistants and residential
Right.
assistants as well.
But I mean, does it apply,
so
so if the individual is, there's no expectation they would report an incident of sexual harassment, anything covered by Title IX, but there is an expectation that the employee would report plagiarism. Is that person a mandatory reporter or not?
The actual language says, who's been given the duty of reporting incidents of sexual violence,
Right, and then
or,
the,
gotta finish, or any other misconduct by students to the Title IX coordinator or other appropriate school designee.
right, so does that mean any other misconduct of a sexual nature that would be reported to the Title IX coordinator? Or does that mean any misconduct that would be reported to any other individual, which would include just about any misconduct in general? I mean, that's to me, is a very unclear definition, and I don't know if the Department of Education has a position on which one it is.
Offhand, I don't know, I'm sorry. What I can do is speak with I can speak with you after the conference.
Okay.
But I'm sure this is a question that many other schools have, and the fact that it's not clear here probably means that there is not direct guidance on that issue. But we can speak more about this
Okay,
as well, sorry.
Counselor?
Risa Lieberwitz, General Counsel, AAUP. I have a few things, and I'm hoping people can respond to them. One is that there are some concerns about universities using OCR's positions on mandatory reporters as justification for having all faculty included as mandatory reporters, even though it's clear that OCR does not require that. And as you've explained, Coleen, this is something that I've heard and other people have heard from faculty who are being told that universities say, well, we have to have mandatory reporters cover everybody on the faculty. Also in line with that, one of the things that hasn't been mentioned here is a risk management kind of approach. It's a lot easier for university administrations to have very broad reporting requirements in order not to have to deal with questions later about whether you're a reporter or not. And I think that has to be discussed because it's not simply what's good for students, it's about risk management in that case for universities. Secondly, I would really like to hear from the Title IX directors or coordinators on the panel. How did you involve faculty in creating these policies and deciding how broad the reporters should be defined? Because I heard a lot about I require and we, but I'm not sure where faculty governance is in that, to follow up from the last thing that we heard. And then finally, there was only a mention earlier during the presentations of faculty concern that this is going to really hurt their relationships with students, and that got kind of poo-pooed. And it seemed to, that's what I was hearing from the panel more. Poo-pooed. Are we really doing something to actually help students trust their faculty members, or are we actually doing things that drive wedges between students and faculty?
Thank you. John?
Well, let me address the,
Who goes first?
yeah, let me address the last point first. So, I don't think, hello? Somebody say something? I don't think we're doing anything that could reasonably be construed as driving a wedge between students and faculty. At least on our campus, the goal has been to increase awareness generally. And we do that by promoting the program so that everyone is invited to take sexual misconduct training on our campus, whether you're a responsible employee or not. Every single member, every new student, new to campus student, transfer student, graduate student, undergraduate student is required to take training on sexual misconduct, and students in certain classifications are also required to take in-person training by myself or another member of the staff so that they have a better appreciation of what their responsibilities are. In addition, we have been working with, and we advise our faculty of this, we've been working with different student groups to increase awareness of our policies and the resources that we have available to address issues that occur. We've been working with our undergraduate student government and with our athletics and with our student organization leaders to increase general awareness of these issues and these resources. And you know, we think a rising tide raises all ships. It creates greater awareness of not only what resources are available, but what policies we have in place and what role students, as students, can play if they see something or if they learn about something and they want to encourage somebody to seek help and assistance and resources. So I don't think we're certainly not trying to drive a wedge or suggest that there is a reason for a difference between how students see other services and resources and staff we have from how they see their faculty. It's just that we want them to understand that if they really do have reporting that they want to make, there's a place to report it where they will get very swift action and attention. On the issue of how we came up with the definition of responsible employee, as I mentioned, Hunter is part of the City University system. The City University made this policy at the system level, so unfortunately I was not involved, and I don't know the extent to which they've involved other faculty in those discussions about responsible employees.
So, what? Yeah, I could speak too. I was not a part of conversations with faculty in terms of making changes to our policy at this point. And we have a policy review committee, and the policy itself, the written policy, is still in the process of being written. We're almost done with the draft on the policy review committee. The provost is there are faculty members there, the VP of Human Resources, our policy person, I can't remember her title, I'm on it. So there's a multitude of people from across many different facets of the university are on this committee, and that is where there will be an opportunity for faculty to respond to this mandate that has been proclaimed at this point on our campus.
Who proclaimed it?
I'm sorry?
Who proclaimed the mandate?
It was the Office of General Counsel, me, SVP of Human Resources, and what we are doing is really trying to work to encourage reporting and explain to our faculty and also all of our employees how important this topic is to us and that we want everybody on our campus to report it. So while we've designated our faculty as mandated reporters, we are, like John said, all of our employees are required to attend this training. It's not just for faculty. And that we do it in person, because we do feel strongly about the subject, and that we have, in the training, we talk about not just the requirements to report, we talk about confidential resources on campus, including a confidential advocate, so that if a student wants to get accommodations, wants to have changes to their academic or living situation, would like to know exactly every step that happens in our process, that student can go to the confidential advocate, and all of those things can take place without anybody knowing why. So a classroom can be changed, a residence hall room can be changed. A student can actually get a full 100% reimbursement on his or her tuition if they come forward to even just the confidential advocate without having any investigation, nothing. They go and make a report to that confidential person. So while there might be some concerns, or while there are, I don't want to take away that there are concerns about conversations that might get more limited. I think that St. John's has really been taking a comprehensive approach to ensure just the safety and security of our student community. I mean,
I think just to quickly, and then I'll sit down, the point here is, it's clear that everybody takes the responsibilities seriously. I think the question is, at what points early do you involve faculty governance bodies, not just committees with some faculty as well as with administrators, but when do you bring them in rather than saying, here's the mandate, now we'll talk about it? What is the way in which definitions are going to be defined, and how do you bring in faculty who have the direct experience into creating policies that affect them? And inadvertently, we want to make sure not to inadvertently shut down the good relationships that occur between faculty and students and the good conversations because somebody has to write on a syllabus anything you tell me. I'm now a mandatory reporter, and I may have to tell somebody if you report some sort of sexual misconduct. These are the kinds of realities that show why faculty governance processes are so important.
Okay. Thanks, Tracy. Fred?
Hi, Ken Ash.
Ken, I'm sorry. It's okay. Just a fellow board member, don't mind me. I'm sorry, Ken.
Ken, the Association of Pennsylvania State College and University Faculties. I think that this ambiguity about whether or not, faculty are mandatory reporters and the silence from OCR about that and leaving it up to them creates real problems for collective bargaining, because it's a very different thing if the interpretation of the law is that universities must do this than it is if they can do it or it's in their up to them to do it, particularly as we start to mount up the number of trainings and the number of hours that faculty have to dedicate towards this. If it's up to the university to whether or not to do it, then it seems to me that would be part of collective bargaining. If the government's saying that you have to do it, it changes the very nature of what's going on. And I know this is not your intention at St. John's, but a university could say, well, it's our opinion that this is it, and we want to go a little bit further. But again, in terms of collective bargaining, we don't know. Is it the law that's doing it, or is it the university that's actually creating the policy?
Did you have a question?
Hello?
We've got about 2 more minutes, and she was in line before, but...
I just want to say on that last point that the law is pretty clear that each institution that receives federal funds has got to reply and respond and conform to Title IX. And one of the requirements is that there be responsible employees who are charged with reviewing and investigating sexual misconduct complaints on each campus. The issue of how you determine who that responsible employee is, as we noted here, does leave some interpretation to the individual college, but there's no doubt that each institution must have a responsible employee. That's not a choice that it has. It's a mandate.
We're just about coming to the close here. No, go ahead and stay. I'm going to speak for the panel that they'll stay for these last 2 questionnaires. Anybody's free to stay who wants to say. If anybody needs to go, you certainly don't need our permission. But I do want to, while everyone's still here, thank the panel for a very, very wonderful presentation. Please go ahead.
Thank you. Part of the focus of the guidance coming out of Washington in Title IX is empowering the victim in understanding what their options are at the university. One of the concerns I have is I'm hearing you suggest that we can have mandatory reporters and then also be encouraging or strongly encouraging the entire community to report. Are we creating confusion for students who might be coming to a faculty member thinking that they're going to a mandatory reporter, but run into somebody who says, well, I think it's just a suggestion, so I won't? And is that creating additional liability risk for the universities?
Thank you. Go ahead, either one of you. I don't.
I don't think so. I mean, as I said, our policies are pretty clear in terms of who's a responsible employee and who isn't, and we do encourage others to come forward. I can tell you that I've been doing this for a while now, and almost 10 years, and I have not had an instance in which a faculty member has learned of something and not brought it to my attention. It doesn't happen very often, but I've never had in any instances in which this distinction that you're raising has been a barrier to people bringing information to my attention. I suppose it could theoretically in some instances, but it hasn't happened.
And I wanted clarity, meaning the distinction between certain faculty who are mandatory reporters and others who are not. And that was certainly a conversation that we had in our campus, that we wanted to ensure that it was clear, especially as faculty wear different hats. Some are in more administrative roles, even though they're professors for a class, but they got a teaching reduction. So we certainly considered that when we were coming to this conclusion of, designating that faculty are mandated reporters, and we also were considering, who is likely to receive a report, and we do see that many of our complaints start in the classroom, and that most of those complainants do want to go forward. And in fact, any that don't want to go forward, once it gets to my office or the Deputy Title IX Coordinator's office, there is still that option to not participate. And if they choose not to participate, we then send them all of the information, all of their rights and responsibilities via email so that we know that, okay, you're not participating, here's the information. We try to get an email back from them letting us know that they don't want to participate. But ultimately, we're not forcing them to participate. We're only forcing the faculty in the first instance to let us know about that incident. And I think that's a clear distinction that I might not have mentioned earlier.
Okay, and as they say in the Navy, our anchor man. Go ahead, please, sir. Your name and institution.
Well, I don't want to get between people and their breaks, so I'll be brief. My name is Richard Hansen, and I'm at De Anza College in California. And I wanted to answer your question to the audience about collective bargaining.
Yes.
And we bargain over these issues. These policies come up, not mandated, but brought down from the feds, OCR in this case, mandating reporting. We bargain the process.
Right.
We deal with what it is at hand, what the college wants to institute, and we bargain it, and they move their process along. And if we have to, we demand to negotiate it because it's a working condition. And one of the things we do, too, is talk about then the process of the investigation, because we're talking a lot about sexual harassment here, but there's all sorts of different discriminatory claims that can be made. And what we've had a hard time with is the investigation itself and the treatment of the accused. And I understand it's about empowering the victim, but the accused has rights, too, to due process. So we've actually gone to PERB on that issue and recently had a strong ruling in favor of getting the collective bargaining agent information, because that's the problem. If you don't get information about what the issues are, then the person who's accused is put in a very weak position, goes into investigation sessions without even knowing what's at issue. And we're getting a pretty clear mandate that we should get that information so we can defend our members.
Thank you for raising that point. I'm actually relatively familiar with the concern that you've raised, and it was important to raise here. Once again, for those who are still here, if you could thank our panel. And I don't know if we sprung for cookies, but something's out there.
This ends a podcast from the 43rd Annual Conference of the National Center for the Study of Collective Bargaining in Higher Education and the Professions at Hunter College in New York City.